Ladies and gentlemen, please join me in welcoming the answer to that question, Michael Madison.
Thank you, Glenn. I can talk about the pit experience maybe in the questions. The situation was actually in some respects worse than he made it sound, and in some respects better. Worse in the sense that they asked everybody from janitors to senior faculty to sign that. They asked adjunct professors to sign that. Better in the sense that none of it was ever followed through on. The provost ultimately responded to the it was more than a kerfuffle, it was like a minor nuclear explosion. The provost responded by pulling the whole proposal off the table, and there is now a committee under Constitution to revise and review the entirety of the IP protocols for the entire campus going forward, and I will be a part of that looking ahead. So, thank you to Glenn for the invitation to be here. As I said before we got started, it was a really interesting opportunity for me to sort of take stock of and synthesize a bunch of things that I think about sort of individually, sort of idiosyncratically, and sort of put them together in a package. So this has been a really great exercise. I'm going to go through a bunch of stuff. I'm going to start with some sort of background disclaimers and some initial assumptions, and then sort of accelerate into some more detailed aspects of how IP law functions and interacts with universities and faculty members. Stop me at any time, ask me questions. I'm going to leave the slides behind, so anybody who would like the slides later will have access to those as well as to the video. First, though, a few just sort of disclosures and disclaimers and expectation setting. I'm a researcher and a scholar and a teacher. I'm a member of the university community at Pitt. I was a practicing lawyer at one point in time in California, but I am no longer a practicing lawyer. So this is not an on-the-ground, in the weeds kind of review. This is not quite 30,000 feet. It's somewhere in between, right? It's an overview that's accessible to a non-technical, non-lawyer's audience, but not so detailed that I'm giving you chapter and verse or code section all the way along. Number two, I'm going to try to cover a broad IP law landscape which covers a lot of different topics rather than focusing just on rights assignments or just on patents or something of that nature. Meaning I will inevitably touch on some things and omit some other things. If I don't touch on something, I'm not going to talk particularly about libraries as such, for example, although that's a really critical part of university life. And then it's partly descriptive, that is just giving an account of what's happening and where things are going, and then partly normative in the sense of sort of why it is the way it is, where it might be going, some costs and benefits to different aspects of what's happening. So ideally, in different respects, to give everyone a guide both to where they are in the university right now as a researcher or as a teacher, or to where they are likely to be going in the future. The slides have a fairly heavy text dimension. Frankly, those are less because I expect you to read the text, much more to help me organize my thoughts. So read as much as you wish, but ignore as much as you wish as well, because I'll talk you through the main points, and then you can take the text away with the slides later. So let me start with some background assumptions. First, some background assumptions about the university, and then some background assumptions next about IP law. These, in both cases, the university and IP, somewhat essentialized and somewhat idealized, but I think it reflects in most respects how we think about who we are and the systems that we live in. With respect to universities, let me start off with those. I think of us mostly in terms of research universities, although of course the population of higher ed is bigger than just research universities, so IP problems affect small colleges and other universities as well as research universities, but I'm going to focus primarily on the research areas. Universities are primarily about creating and disseminating knowledge, right? This is nothing that's new to this group. I think of universities as commons, to reflect my research area. Commons not in the sense of it's an open public free-for-all, but commons in the sense that it's a set of institutions. Commons come with rules. Commons come with guidelines. They may be formal, published governance mechanisms. They may be informal, customary, traditional, but they are sets of expectations that communities use to guide themselves. And those are big, big parts of universities, historically as well as today. They operate at small levels. They operate at large levels. The big features of the universities as commons, though, is their self-governing character, right? So they're mostly thought of as pretty autonomous organizations and institutions at the unit level, at the school or college level, at the university level as a whole. faculty governance, academic freedom, autonomy of thought, choosing your research subjects, choosing how to teach, choosing how to interact with students. Those are all things that we get to do for ourselves in accordance with university and higher education traditions, not because the government at any level tells us that that's required or that we're accountable in court, for example, most of the time for making some wrong decision. The character of the knowledge production and distribution function is almost inherently global, or at least sort of trans-border. We don't think of universities or higher ed as sort of the knowledge is fixed in place. We're all in a specific geographic location, and some of us have more regional or local kinds of payoffs or accountabilities, but the knowledge function itself is inherently sort of very open-ended and broad, and that's a fairly important feature. And then the last thing to take account of importantly are two other things. One is that universities are special kinds of organizations, special kinds of institutions. They're not like regular corporations, although universities are sometimes organized legally as corporations, but they're not really like companies. They're not expected to behave like companies. They're not regulated legally like companies. They're not organized and governed like companies. They're nonprofits. But we're not like other nonprofits either. We don't really behave like other nonprofits behave. We're not organized like other nonprofits. We're like this third thing, which is reasonably unique in the cultural world and in the legal world, and that's an important place to kind of start as a baseline. That said, like corporations, like nonprofits, universities need money. And so you all know that. Money has to come from somewhere. Money has to come from tuition. It has to come from endowments. It has to come from industry. It has to come from the government. And, we all need cash in different respects to make the enterprise go. And we all know that. It's important to recognize how that's going to start to interact with other considerations. The money is partly a clue to what's to follow. So let me shift from the university over into the IP system just to contrast some of the basic expectations and assumptions about IP with what we start with in terms of the university. There are three core domains of IP law, just as a very quick summary. I'll give you some more details in a moment. But you've got patent law, you've got copyright law, and you've got trademark law. IP, like universities, is about knowledge. IP is about producing and disseminating knowledge. It's about motivating people to do those things by giving them the opportunity to get compensated for it. But the underlying sort of expectations and assumptions about IP as a system for regulating knowledge is very different. Right? The idea of IP law is that IP laws encourage people to make IP things or IP objects, little commodities. Commodities are sold into markets. They are bought and sold and traded in markets. You get industrial organizations. You get money changing hands. Markets are the way that knowledge is created, distributed, and consumed. Note the obvious contrast with the basic assumptions about how universities operate. Market competition is the touchstone, and I focus on the competition aspect in part because that's a way to connect trademarks, which are more about competition policy, to patents and copyrights, which have additional things going on. IP rights are basically national, right? So every country has its own domestic system of IP laws. Those systems are linked through international treaties, but it's a core principle of IP practice that you focus on American copyright law for American copyright practice, American patent law for American practice, and so forth. Same with trademarks, same with other aspects of IP law. So IP law stops at the border. This is a very important feature of the legal system. Also, there are other aspects of the legal system that touch on intellectual property in addition to intellectual property law. This is something that not only affects how people behave in markets and industries, but it also will turn out to have some bearing on life in IP in the universities. Think about tax law, think about employment law, think about securities law, think about antitrust law, think about national security law, which has a surprising overlap with intellectual property law. So when you think about the IP legal system and IP content, you're thinking not only about IP law, you're thinking about the intersection of a lot of other things. The big one that I haven't listed, but probably the most important one for our purposes, is contract law. Contract law has an enormous bearing on how IP systems function, and the key thing about contract law is that from a legal system standpoint, contract law is state law, whereas IP law is almost entirely federal law. So you've got this jurisdictional interaction, which is very interesting. So the last thing to note about IP as a sort of assumption is that IP law is designed to be essentially universalizing. It's supposed to be sort of cross industries, cross markets, IP regimes, IP presumptions, what's patentable, what's copyright, what's a trademark. Those are designed to be universal. They're designed to go everywhere. And what you see over the history of IP law, especially in this country, is the gradual expansion of the subject matter of copyright, expansion of the subject matter of patent, expansion of the subject matter of trademark to cover ever more stuff, ever more areas of cultural and economic life. And again, that becomes important. So let's move to some more specific stuff, just a very quick thumbnail review of what patent law is, what copyright law is, and what trademark law is, just for a refresher for those of you who are already acquainted, an introduction to those of you who are not. Right? So patents. Patents deal with technology. The law covers patenting new, non-obvious, and useful machines, processes, compositions of matter. The basic idea here is technology. The basic idea here is applications of technology rather than basic propositions or basic science that have to be reduced to some concrete form. Patents are issued only by the Federal Patent Office, only after a long, arduous, and expensive process of negotiation. So you have to have a document that clearly defines the scope of the patent. The patent is valid only for a relatively short period of time, 20 years from the filing of the patent. That's how long that it lasts. It's possible to get some sort of pre-patent kind of protection under certain circumstances, things called provisional patents, which are effectively a way of holding your place in the queue for a possible future patent. You can get kind of a pre-clearance, called a provisional patent, for a year ahead of time. Patent rights are owned by the people who invent the invention. Patent rights, in the first place, this is important, only belong to actual individual human beings. It's very typical for there to be multiple inventors or co-inventors on a current invention. Most patents in this country are assigned by agreement from the individual human inventors to their employers, whether it's a company or a university or some other enterprise. Most patents end up being owned by corporate interests, but there is an actual transfer of ownership that has to take place by the individual employee to the enterprise. A couple of other nuances to patents that particularly affect academic life. One has to do with disclosure of the patented information or the invention prior to the patenting process itself. The point of novel, non-obvious, and useful things being patentable is that these are new things. These are things or inventions that are not previously known to the relevant scientific community. Therefore, if it has been known previously or disclosed previously, say in a paper or by a poster or some other sort of open sharing mechanism, as is common in academic research, that compromises the ability to get a later patent on that same material. There are statutory mechanisms to protect against fatally losing your rights, but the guideline in this country is you have a 1-year clock starts to tick once you've made a public disclosure. Outside of the US, however, you may have no clock whatsoever. So if you have any concern about possible foreign disclosures or foreign patent rights, for example, there is just the general guideline is be very, very careful about any public disclosure if you're interested in possibly patenting. And on the flip side, using patented technology is a potentially dicey thing as well. You don't have to know that there's a patent to be possibly liable for using a patented technology. There is no fair use exception of any significance in patent law. If you use the patented technology, you can be liable for patent infringement, even if you're simply using it in what you think of as pure research in an academic setting. So they're very powerful rights, both going and coming. But fortunately, they don't last that long. They only last 20 years. And in the scheme of IP law, that's a good thing. Copyrights, let's shift gears to copyrights for a moment. Copyrights work differently. Copyright law covers what is called expression, or in the language of copyright law, original works of authorship. So here we're talking about art, literature, music, graphic arts, painting, photography, sculpture, dance, choreography, architecture, computer software can be copyrighted. It's a very, very broad domain of human creativity, so long as that human creativity is reduced to some fixed medium. So improvisational content generally cannot be copyrighted. Anything that is documented electronically or in an analog form typically can be. Creativity, however, has a very low threshold in copyright law. Patent law, something has to be inventive using the legal framework. Copyright law, it only has to be minimally creative. And that means that copyrights are everywhere all the time the moment that something minimally creative has been identified. And you don't need the government copyright office to declare that you have copyrighted something. Copyrights arise automatically and instantly. Every time you turn around and take a note in a class, when that class is done, you may have a copyrighted work by virtue of having created something minimally creative on your notepad or on your laptop. And that creates opportunities. It also creates hazards. Copyright lasts a long time. Patents last only 20 years. Copyrights, I'm going to say functionally speaking, for all practical purposes, copyrights never expire. In real world terms, what that means is that anything in this country created, meaning published, since 1923, so essentially going back 90 years, we should assume, until something shows us to the contrary, assume that anything created and published during the 20th century is potentially the subject of copyright protection. Anything that is created today is going to be subject to copyright protection until your grandchildren have passed away. It's a really, really long period of time. Now, the length of copyright protection and the breadth of the things that it applies to are mitigated in a couple of ways. One, they're mitigated by the fact that copyright law requires that we think about distinguishing between expression, the details, which can be protected by copyright, and general ideas, which cannot be protected by copyright. So every time you look at a book or a song or a painting or a computer program, your copyright lawyer is always thinking about what level we're analyzing, expression or idea. Copyright has the doctrine of fair use, which we're all at least passingly acquainted with, which has some uncertainties associated with it, but which is kind of a get-out-of-jail-free card under certain circumstances, particularly if you are engaged in research or teaching or scholarship or similar things. Copyright belongs to the author, so the person who creates the work owns the work to begin with, but of course, like patents, copyrights can be assigned by contract. Copyright also has something called the work-made-for-hire doctrine, meaning that if you're an employee and you're working in your employment, your copyrights belong to your employer automatically. Automatically. Now, in universities, there is this something called the teacher exception that some people think exempts academic researchers and teachers from the work-made-for-hire doctrine, but that's not baked in stone. It's a judicial doctrine. It's not a statutory doctrine. We'll come back to a little bit of that later on. Okay, last, by way of wind-up, trademark law. Trademark law, we often think, doesn't have as much to do with university life, but I'm going to make the case that it does. Trademarks are signs and symbols that are used in advertising and marketing. Almost anything that is used as a sign or a symbol in advertising or marketing can be a trademark. So you think of the name of a product, you think of the slogan, you think of the logo, but you might also think of the design, the shape, the Coke bottle. You might think of the smell. You might think I talk to my students about scented motor oil. And you wouldn't imagine that such a thing exists, but it does. All kinds of scented motor oils. You don't want your lawnmower to smell bad, make it smell like gardenias. You can do this. Or sounds, and there's all kinds of sounds you can imagine that are protected as trademarks. Think of that bell that Southwest Airlines plays. You are now free to get up and move about the country. That sound is a trademark. The lion's roar for MGM. All kinds of things will come to mind when you start thinking about this. Trademarks are a different kind of intellectual property. They do not give property-like rights the way that copyrights and trademarks do, at least not typically. Trademarks function as a kind of way, a way to protect consumers. It's kind of a consumer protection strategy. You know what you're going to buy because the trademark guarantees that it comes from the right company. Right? So trademark law then means that if another company uses that same trademark deceptively, in a confusing way, so that's promoting, so you're going to get a counterfeit product because the Rolex brand looks like it's authentic. That counterfeiting, that sense of confusion is the trigger for something wrong happening in trademark law. So consumer confusion is the touchstone, unlike copying or unauthorized distribution in copyright or patent law. Now, the fact that trademarks come from a consumer protection background, however, leads to some complications because consumers cannot sue for trademark infringement. Only competitors of the trademark owner can sue for trademark infringement. And if competitors own the trademarks, that means competitors like to treat them like property rights, like to make money off them as if they are kinds of private property rights. Businesses that own trademarks want to protect their goodwill. And so that's where you start to see trademarks looking like copyrights and patents as forms of intellectual property. In all three areas, I just included it on this slide as well as on the other two, there are countervailing interests to pay attention to in terms of free speech, in terms of free expression, in terms of parody, criticism, all kinds of uses of IP that really should be beyond the control of the IP rights owner, but are therefore very controversial and the subject of a lot of contention and litigation. So now, intersections between the university and IP. So I've set up sort of universities as one style of system subject to a set of expectations and norms. IP in both general and specific ways as a different set of expectations and norms, all concerning knowledge, right? So knowledge is the thing where these things overlap. And you get the production and distribution of knowledge in universities that comes from this very self-governing, semi-autonomous, customary, traditional way where sharing is really the whole point. That's the commons idea, sharing. An IP law, which is this universalized, more abstract, market-oriented system of control with limited exceptions. And so the philosophy as well as the practicality of IP and universities really start off as being kind of at odds in sort of a fundamental way. So here's my argument. So here's a little bit of a note about the normative as well as the descriptive. So this is a problem. And it's a problem both at the university level, that is, it's a problem at the institutional level, and it's also a problem at the individual faculty or scholar or teacher level. And it's a problem in two overlapping respects, one of which is a little bit easier to grapple with on the ground than the other. One sense in which it's a problem is that the university, as I said at the outset, needs money, and IP resources in the hands of the university and IP resources in the hands of faculty members are ways for universities to make money to fund operations. And that's just a reality of the fact that money is short. And universities are looking for ways to raise revenue in all kinds of ways, and IP can sometimes be a way to do that. That's, in some ways, the more tractable aspect of the problem, in the sense that if you can get money from other sources to compensate for gaps, you don't need to put so much pressure on IP development. The less tractable problem, the one that's harder to deal with, has to do with the logic of IP law as an independent system. IP law, because of its grounding in the marketplace, is subject to some of the inexorable laws of the marketplace, and one of the observed inexorable laws of the marketplace is that the marketplace has a tendency to expand into all areas where the marketplace might expand, and so something that looks like a market, or the potential market, has a tendency sometimes to become a market. So as IP rights expand, and the logic of IP rights expand as universal structures for governing knowledge, IP lawyers, IP judges, IP legislators have a tendency to look at the university and say, you're not such an unusual, distinct place after all. You are just another potential market. You are just another bunch of market actors. You're just a bunch of producers and consumers and negotiators. You're not special in any way just because you happen to inhabit this 1,000-year-old institution that's thrived without being part of the market. Okay, so how does this actually pay off in concrete terms in terms of patent law, copyright law, and trademark? So start with patents. The big issue in patents, as most people know, is the Bayh-Dole statute and the technology transfer or translational research or commercialization dimension. So for those of you who aren't familiar with this, in 1980, Congress passed something called the Bayh-Dole Act, which is something of a constitutional charter for university technology transfer. The Bayh-Dole Act is still very much in the forefront of how universities think about inventions, technology products that come out of science and engineering and some other areas of the university. The Bayh-Dole statute says basically that if you get federal sponsored research money into your university, and if inventions come out of that sponsored research, then the university has the choice, if the university wants to take title to those inventions, patent them, and commercialize them through licensing, transfer, company formation, and other things. Sometimes the Bayh-Dole statute is mythologized as requiring that universities do that, but universities are not required to that. Most universities do require that their faculty assign inventions to the university, but it is an option. It is a strategic choice that universities make. If universities do take title to those inventions, then other things kick in. Having taken title, the university is required to protect the title, to try to commercialize it, and to try to make money out of it. So this leads to something I'll get to in a few minutes, which is policies that most universities have put in place regarding how faculty and collaborators are compensated, if at all, for the fact that they've contributed those inventions to the universities. But the thing to note at the macro level for the moment is how the technology patenting and commercialization imperative that follows from Bayh-Dole, this policy that universities really should be in this business, is the public policy message, has led to the creation of technology transfer offices at most research universities around the country. Nationwide, the annual revenue across all of the technology transfer processes across all universities is about a little bit more than $2 billion per year, which across all collective universities. That sounds like a lot of money. I'm going to impress you in a little bit with even more money than that. But starting from a sort of a standing start in 1980, 35 years ago, zero, roughly, not perfectly zero, but roughly zero in 1980 to $2 billion today is a lot of progress in a relatively short period of time. Now, there's some serious drawbacks to all of this. Let me just quickly highlight some of them. One is that universities take the technology transfer imperative sometimes and use it as an excuse to try to generate a culture of innovation on campus, or a culture of entrepreneurship on campus. That can have some benefits. It can also have some obvious drawbacks in terms of how faculty are spending their time. One possible drawback: it attracts faculty to pursue research projects that are fundable and fundable in specific ways, right? So I have a colleague, Kathy Strandberg at NYU, who has studied this from a law and public policy standpoint, and who argues that faculty are biasing their research in some respects to move into areas that are fundable and patentable, which is getting them away in some respects from sort of the inquiry-driven, curiosity-driven research of things that are inherently interesting and worth pursuing. So that's one possible cost. Second possible cost: as universities own patents, commercialize them, and license them, universities have no public policy mandates to be public-spirited about this. Universities are absolutely entitled to be proprietors of their own patents and to make the best deals that they think they can make with them. They may choose to be public-spirited and generous and license their technology to end users or other partners at low royalty rates, or to approach underserved communities, or distribute the technology worldwide in ways that the industry would not otherwise do, but there's no requirement that they do that. And if universities choose to be overbearing, aggressive, patent litigants, and so forth, they can be, and have been in some cases. So if any of you are aware of the controversy over the last few years over what's called the BRCA, breast cancer detection genes, or BRCA sometimes called, the Myriad lawsuit that went to the Supreme Court about whether, in effect, gene sequence can be patented. Very controversial area of practice. The thing to remember is that the University of Utah is where that technology was developed, and it was the University of Utah whose enforcement strategies were in part behind this very, very aggressive enforcement campaign in the Myriad case. So let me shift gears to talking a little bit about faculty policies that universities have in place to deal with this. In your faculty handbook, or maybe as an independently published policy, there's almost inevitably going to be a document that summarizes faculty obligations to assign their inventions to the university and what faculty get as a result if that device or technology is patented and then commercialized. So I'll give my university as an example of a relatively traditional approach. Notwithstanding this episode that was described at the outset, Pitt requires research faculty to disclose inventions to our technology transfer office, which then will choose whether or not to take title to them and to patent them. If the university patents a technology, then the royalty stream that comes in at the back end is divided in roughly three ways. The faculty inventor is assured at least a 30% of any anticipated royalties. The department gets about 30%. The university taxes about a 30% aspect of this. And that's the basic one-third, one-third, one-third allocation. It's a fairly typical allocation. I was curious to see what Stanford does. Stanford is a much larger scale, better known enterprise for this sort of thing. Stanford, one-third, one-third, one-third. It's a pretty typical allocation. What varies from school to school is not the royalty calculation so much, although I'll give you an outlier example on that score in a moment. It has to do with equity, right? So if you're licensing the technology outward from the university, faculty might be interested in forming a small company and being the licensee as well as the inventor. Can the faculty member then participate in management of that small company or own equity in that small company? This is where universities vary a lot. Right, so my university is very traditional in this respect. We really hate the idea that faculty members might have some sort of conflict of interest, then their time might be allocated to the wrong function, they might be thinking the wrong thoughts, they might compromise the pure research mission of the university. We do not want our research faculty to own equity in outside companies. We do not want our research faculty to be managers of outside companies and technology that they've invented. So there's really a heavy hand discouraging that in the policy. Down the street from me, literally a half a mile from my law school, is Carnegie Mellon University. So let me give you the Carnegie Mellon experience, sort of to give you the contrast, right? So Carnegie Mellon basically says, faculty, you own your inventions, you should assign them to the university. The university will choose whether to commercialize them, right? So the same starting point. If the university commercializes those inventions at Carnegie Mellon, CMU, interestingly enough, CMU will take 15%. You get to keep everything else. CMU faculty who want to own companies or take equity in companies or be managers or owners of, or CEOs of companies, knock yourself out. Essentially no limitations on that at Carnegie Mellon whatsoever. So of course what you see between the two universities, you have different research profiles. Pitt is much more life sciences and NIH funded, and Carnegie Mellon is much more IT, engineering, robotics, and NSF funded. But that held constant. CMU is a much livelier place in terms of faculty commercialization, startup formation, number of licenses, value of licenses, faculty recruitment, which is heavily invested with the opportunities to make outside money in this respect. Pitt has a much harder time competing on all those metrics, has some difficulty recruiting outside faculty because they can't have the outside revenue opportunities that they might have at some of their other institutions. Stanford is a different model. They have the same one-third allocation of royalty income. Stanford, however, is extremely generous with the equity side. Right? So if you form a small company and take equity in a small company as a licensee of your own invention, Stanford will split the equity with you. Right? So this reflects kind of a Silicon Valley thinking, which of course is the way to get rich, is to found a company, take equity in the company, and then cash out of that company at the back end. Right? So there's sort of cultural differences related to geography, but also cultural differences related to thinking about the role of the university in the research enterprise versus the role of the university as a proprietor in the public in the patent system. I should note, last couple notes about patents. There are some other models for this. So I've given you some detailed variation in patent policies. The AAUP and the Kauffman Foundation, which is very invested in entrepreneurship nationwide, both have proposed that faculty inventors be permitted to keep their own invention rights, that universities not take title, and that faculty basically be permitted to decide for themselves whether or not to be entrepreneurs. So I might be a faculty inventor at Pitt, but I might decide that Syracuse's technology transfer office is a better partner for me, so I might shout my invention to Syracuse. You might be able to do me a better deal, make me more money, and make a better deal for Syracuse than my own home tech transfer office at Pitt. Right? So the good news is that restores a sense of faculty autonomy to whether or not to commercialize something. The bad news, of course, is that it makes me more of a market participant in some fundamental respect than I ever was before. The AAUP and Kauffman proposals haven't gotten really any traction. There's a lot of skepticism. There's a lot of sense of, this is our resources built this invention, so our university should control it. But it's interesting to note that there is some conversation going on around this. The last thing to note in the patent area has to do with industry. So I've been talking about federal sponsorship, but of course federal sponsorship is flat or declining. What's on the rise is industry sponsorship of scientific and engineering research. The complications there are that industry sponsorships come with contractual obligations regarding who owns what at the back end rather than regulatory limitations provided by federal law. Right? So it really is a case of what your counsel's office or your technology transfer office might negotiate on behalf of faculty to advance the mission of the university, the idea of basic science, to protect the nonprofit tax status of the university, to protect against complications from export controls, to protect the industry funders' legitimate interest that if they're giving you money, they're going to get something at the back end. So lots of things are on the table. Mission can be complicated by the fact that at some point you all need money to run your labs. Right? So let me shift from patent stuff to copyright stuff. So particularly for those of you in the humanities or social sciences where the patent dimensions are not quite as compelling. So let's start with publishing, and this does affect, of course, everybody, whether you're in the humanities or social sciences or otherwise. The classic model where academic journal scholarship, or frankly monographs, the copyrights in those works were assigned to publishers, and you ended up either having to pay the publishers to publish your work, or at the very least you assigned your publishers and got very little in return. The publishers would control all forward distribution of your work, and you had a hard time even using it in your own classrooms, for example. That's been under attack for about a decade or so now. In some fields, so the classic domain, the classic principle still applies, requires that you assign the copyright. These are fields especially where the leading journals are published by professional societies rather than by academic organizations. So I always hold up the chemists. The American Chemical Society, which publishes the leading journal, the American Chemical Society is a very, very traditional academic publisher. They require that you assign the copyright. They have very, very limited redistribution rights and so forth. Contrast the chemists with the physicists. The physicists figured out how to do things entirely different. The physicists have a very generous open access archiving system, very much encourage publication in situations where the scholar or the author retains the copyright and controls the terms on which that is shared with colleagues and beyond, leading to a much more robust and very early system of widespread sharing and reuse of physics and astrophysics scholarships. The libraries and a lot of research universities have gotten very active in the last few years in developing open access policies for journal scholarship across the entire campus. Harvard was an institutional leader in this. MIT came along relatively quickly after that. I was involved in an effort to develop one of these campus-wide policies at Pitt a couple of years ago. The idea, there's different nuances to this, but the idea is that every journal article published by any tenured faculty or tenure stream faculty on that campus is by presumption deemed to be open access for purposes of a university repository that's housed in the library, that's made publicly accessible. Any downstream publication rights are subject to the pre-existing open access obligation. So the idea is so effectively to mandate the creation of a publicly accessible archive of all academic research coming out of that institution, much of which is funded by public money. So why should it not be, therefore, accessible to the public? It has a couple of sort of side benefits. One side benefit that the librarians are very conscious of is that it gives the librarians a negotiating tool in negotiating licensing rates with the journal publishers themselves. So you all know that journal scholarship has been very expensive to license in as a digital matter. How do you bargain down the cost of those license rates, build an offsetting asset that you can use as a negotiating tool? And so the librarians are very conscious of the economic logic of this, as well as the sort of philosophical access to information logic of this. The thing to note about open access policies, both in the micro individual scholar domain and at the disciplinary or institutional domain, is that it works on behalf of scholars via collective action. It's very difficult for this to be achieved via individual negotiation. It really happens on a field by field, school by school, university by university level. My World Legal Scholarship, virtually all of the academic journals, which I know are published by law schools and students, but they are our journals. Virtually all of the journals in my world are open access journals. Virtually every author agreement that we all sign in law is an open access agreement, and that's because over the last decade, the law professors have basically figured out that this works. The economics do not make it all fall apart. Other aspects of copyright and ownership. Ownership is a complicated question in the copyright landscape because ownership touches so many different possible things. So I've talked about ownership of rights to journal articles and monographs. Scholarly work, universities typically deem that to be owned by individual faculty, by policy. even though the law might give universities the power to say that these things are works made for hire and owned by the university. It is a rare, not unheard of, but rare thing for a university to claim ownership in scholarly work. And frankly, the reason is that most of the time, universities do not want to own your scholarly work, because if you own the copyright, the university owns any possible liabilities. Sometimes scholarly work brings problems of defamation, privacy, other kinds of accountability to the subjects of the research, and universities want to stay as far away from that usually as they can possibly manage. The exception often, and especially on my campus, the exception is software. Software can be copyrighted. Software can also be commercialized and can be worth money, like a patented technology. Universities sometimes like to claim ownership of software products distinct from so-called classic or traditional scholarship. Other kinds of ownership questions get complicated. Think about data sets. There's so much data-based research on campuses these days. Who owns the database? Who owns the data set? Classic copyright law largely would say, in the abstract, data collections cannot be copyrighted to begin with because there is no creativity associated with the data. Data are facts. Collections of data are facts. There's nothing original or creative about that. Same with syllabi. Faculty often want to say, I own my syllabus, I own that aspect of my teaching material. Again, copyright law often would be very skeptical of the idea that a syllabus is creative enough to be claimed in a copyright. Think about a recipe for an elaborate dish in a restaurant. Copyright law says that recipes cannot be copyrighted. You cannot copyright how you make food. So by analogy, you should not be able to copyright how you teach a class. Nonetheless, I know that faculty often feel very strongly and proprietary about how they teach a class. Faculty feel very possessive because of the resources that they've put into creating and curating large data sets. So this turns out to be more a matter of university policy and practice rather than a matter of default copyright law. Meaning that if you are within a university campus environment, you look to your counsel's office, your technology transfer office, if they're involved in this aspect of things, to look to see what the policy might say regarding ownership of such things. If you change campuses, if you move from one institution to another, you may be on your own. Because between campuses, one campus policy is not necessarily going to carry over to another. I'm going to skip over. I'm not going to talk about fair use and course reserves too much in the talk, but if you have questions about that, there's some interesting things happening there. And MOOCs and online education is such a new area that it's really unclear who owns what. The MOOC providers, the commercial MOOC providers, typically say, faculty, you still own whatever you owned before you came online. So look to your default campus policies regarding ownership of teaching materials. The thing that you need to know if you're interested in becoming part of an online course is that your teaching materials have to get licensed to your university so that your university can license them to Coursera or Udacity or Moodle or whoever you're using. So you are part of a market transaction online in some technical way, in a way that you're not if you're in a traditional classroom. So the last big topic I wanted to talk about, and it's a little bit surprising because of the usual association of IP with copyright and trademark, copyright and patent. The last topic is trademark law. This is an area that is not going to affect the individual faculty members' day-to-day scholarly life as much as copyright and patent would, but it affects your existence in a university environment perhaps as much as anything else. So you all know the broad social and cultural trends interested in branding. Universities are not immune from this in any respect. Individual faculty members are no more immune from this as individuals than celebrities, athletes, and the like. And it's not just faculty members, it's students. I was telling Glenn at lunch. If any of you follow college football, you know the name Johnny Manziel, who when he was in college at Texas A&M University a couple of years ago, he acquired the nickname Johnny Football. And before he got drafted by the Cleveland Browns and went into the drug rehab. But Johnny Football at Texas A&M was not just his nickname, it was his registered trademark. Robert Griffin III, who was the quarterback for the Baylor Bears football team a few years ago before he got drafted by the Washington Redskins. RG3 was his nickname, a registered trademark. Individual faculty are often told, cultivate your brand. Right, so Glenn found my blog, and I've got a Twitter account, and I've got a website for my research project, and I'm because I teach this stuff, I'm very aware of my brand in my field. What's interesting is, of course, these brands, which are just marketing phenomena, can be translated at the institutional level into money. and are being translated into money on a very large and very aggressive scale by universities. This can be traced back to the early 1970s. So we're talking about 45 years ago. The early 70s was the rise of big-time college sports on TV. Colleges realized that there's a lot of money to be made in broadcast rights, so they started registering trademarks with the Federal Trademark Office and university names, colors, logos, insignia, mascots, the classic sort of core stuff, the name of the school, the colors of the school, the logo of the school. From there, universities started getting trademarks in a lot of other things related to athletic programs. So what you see are a given name can get multiple trademarks because it's associated with different kinds of products. So my university, for example, University of Pittsburgh, we have University of Pittsburgh as a trademark for education services. We also have University of Pittsburgh and Pitt as trademarks for athletic services. We also have trademarks for Pitt and Pittsburgh for ice cream novelties, right? Things that you sell at the games. Hats, shirts, foam fingers, stuffed panthers, or do you have a stuffed anything at stuffed oranges? Out of the orange, okay. So all of that stuff, separate trademarks, right? So I have a colleague at Duquesne University who studies this stuff. So there's these phases of trademark registrations by universities, starting with the core stuff in the 70s and early 80s, shifting into sort of big-time athletic stuff in the 80s and 90s. The biggest growth area for trademark registrations across the country with colleges and universities, this is why it's relevant to you, is academic programs. Right? Colleges, schools, departments, conferences, individual programs, student recruitment, healthcare services, all these little things that individual faculty members run, or the departments run, or that research groups run, trademark registrations. Distinguish yourself, leverage it, and see if you can make some money off of it. Primarily in terms of licensing these things, right? Primarily in terms of trying to build partnerships and get royalty revenue, but some universities are very aggressively involved in suing people. Sometimes, once in a while, once in a while they even sue their own students. It's more often, however, that they sue people in the community. University of Alabama, for example, has been quite notorious about this recently. There's a bakery down in Tuscaloosa that was baking cookies with the script A that characterizes the University of Alabama. Boom, got the cease and desist, got the lawsuit. There was a painter who was painting paintings of University of Alabama football players. I have a former student whose den, his father's den was decorated with these paintings because they were big Bama fans. Boom, went all the way to the Court of Appeals on the conflict between trademark rights and the colors and the free speech rights of the paintings. Here's the thing. How much money do colleges and universities make nationwide on an annual basis through trademark royalties? More than $4 billion, right? So patent licensing, $2 billion, trademark rights, $4 billion, right? So this is, I think, really where we talk about the corrosive effect of on higher education of big-time athletics, particularly football, baseball. Syracuse, like Pitt, now part of the Atlantic Coast Conference. All the payoffs of this to be determined in full. The TV broadcast royalties, obviously a big driver of all this. But there's a lot of this tectonic movement below the surface in terms of how all the other aspects of the campus are aligning with IP rights and IP systems that as faculty members or future faculty members, it's important to be aware of these trends because it's filtering down beyond the scientific research faculty who are expected to patent down to, I run a little innovation program at Pitt. I've got my own URL. I've got my own little logo. I do a variety of things to kind of brand and market my program to my current students, my future students, my alumni, my partners in the community, and so forth. I don't really participate in the university's IP system and licensing program. Don't tell my colleagues on the other side of the campus because I don't like the idea that I'm doing that sort of to advance the commercial interests of the university, but I'm used to doing it to advance my students' interests. But it's an insidious character to that, right? Because it is sort of in conflict with what I started about, sort of the core, the soul of the university. So, last point, and then I'll stop. You can ask questions and have the responses. Is there anything that we can do about this, right? So that's the normative conclusion. And I'm actually pretty cynical about the prospect of doing anything about this because the money pressures are so compelling and the logic of IP law as a system is quite overwhelming. However, The open access movement in journal publishing is quite telling, and I think if there's a ray of hope, that's it. And not just in the context of open access itself, but in how that progress has been achieved. That's really been collective efforts by faculties across the country in the area of journal publishing. Right? So individual faculty members, you get so tied up with your own research, your own teaching, progress towards tenure. Once you have tenure, whatever you want to focus on is kind of up to you. It's a very, my family calls it, it's a very monastic kind of culture, right? So you have to learn to be comfortable spending a lot of time on your own, and you prize that autonomy and independence of what makes the university system really function well, is that you don't have to spend all your time collaborating with all of your departmental colleagues all the time about everything that you want to do. You choose what to teach, you choose what to research, you choose how to mentor your students, etc. That culture of individuality can get in the way of effective collective action. So if it's possible to overcome those barriers to collective action and to work as a field, to work as a discipline, to work as a school or a department or a university, the power of the collective is quite important. And if there's a rebalancing to be achieved, I think that's the way that it's going to be accomplished. And with that, I'll stop.